You are listening to Follow That Case, a legal podcast by award-winning attorney Leland Fox, aka Fickle Father, aka me. Coming at you literally from my bedroom closet, I'm bringing joy into your life like only civil lawsuits can. So subscribe, and let's get civil. All right, let's start with Disney versus DeSantis here. I'm going to do a very brief, hopefully, recap of where we are, but we're talking about the Reedy Creek Improvement District, which is, I view as the HOA where Disney World is located. It was overseen by a board that was picked by Disney. And then what happened was in 2022, early 22, March of 2022, I believe, Florida passed the Parental Rights and Education Act, which was also called the Don't Say Gay Law, which basically prohibited classroom instruction related to, sexual orientation, gender identity, things of that nature. And Disney spoke out against that passing of the law, basically said they're going to work to get it overturned. DeSantis really didn't like that. He looked at the Florida Constitution, which was enacted or amended 1 year after the creation of Reedy Creek. And in that Constitution, it says that you can't, public business can't have any special treatment in the law. And so he called a proclamation, wanted the legislature to consider whether the special district of Disney's HOA, was against the Florida Constitution. And so they met, discussed it in Senate Bill 4C, and in Senate Bill 4C, they decided that any independent special district established prior to the 1968 Florida Constitution would be, if it's not reestablished, re-ratified, or otherwise reconstituted, it would be dissolved effective June 1 of 2023, which means that Reedy Creek was going to be dissolved about a year later. That caused a lot of panic. Forbes, you see here, there was a lot of talk that Disney World losing a special district would result in a lot of tax burdens to the counties of Orange and Osceola, where it straddles those two counties. That's not true anymore because the Florida legislature passed House Bill 9B, which did reconstitute the district. And as part of that, they changed the name from Reedy Creek to the Central Florida Tourism Oversight District. And Ron DeSantis was able to appoint his own board of his own people. And I went over this board last time. I'm not going to do it now. But basically, he's hand-selected these people, and they were confirmed by the Senate. And then, in response to that, Disney World entered into its own contract agreements before this new board could take over. And this basically gave them control over the development of the HOA property. And this was for a duration of 30 years. So it basically stripped the board of its ability to do much because it would be contractually bound to honor these contracts. DeSantis, of course, didn't like that, so he issued a letter to his chief inspector general saying, I want you to investigate Disney, I want you to investigate that board, and if there's any wrongdoing, report them to the proper authorities, AA law enforcement. This was also, I believe, sent to the Commissioner Mark Glass of the Florida Department of Law Enforcement. And in addition, the board here determined that they were going to treat these agreements as void for certain problems with the procedures and substantive issues that they felt were there. And so in response to these two things, Disney filed this lawsuit. And that's basically where we are today, except for, in addition, since that time, the Florida legislature has passed Senate Bill 1604, which basically says that any contract that's entered into within 3 months after the appointment of a new board, or before appointment of a new board, the new board gets to look at it, and they'll have 4 months to basically decide if they're going to reaffirm that contract or not. And guess what's going to happen? Or maybe, I guess already did. The new board decided that they were going to avoid these. So that's where we are in the scheme of things. That's the recap. And now let's get into the actual lawsuit. So I'm going to first look at the lawsuit by Disney, and then I'll look at the lawsuit that was filed by the board. Okay, so I've got here this is actually the amended complaint by Disney versus DeSantis. And again, this was amended basically just to include the Senate Bill 1604 to make sure that's within the scope of the lawsuit. So they filed an amended complaint. And most of it is just the story that we've already gone over. So I'm just going to go ahead and go to the causes of action. I've gone through already and kind of highlighted the parts that I want to talk about. So there are 5 causes of action here, and 4 of them specifically relate to the contracts and want the court to rule that those contracts are enforceable and that DeSantis's conduct against Disney in relation to those contracts was wrongful. And the 5th cause of action is more broad. So let's just go over those. The first cause of action is the Contracts Clause violation. The Contracts Clause provides that no state shall pass any law impairing the obligation of contracts. And what they're specifically saying in this case is that a law that impairs a government entity's own contracts with a private actor is subject to heightened judicial scrutiny, which means that in order for it to pass that scrutiny, the government action has to be necessary to serve an important government interest. And in this case, what Disney is saying is that the contracts were abrogated as part of an explicit campaign of official government retaliation against Disney for expressing a viewpoint the governor and legislature disagreed with. And they're saying any other asserted reason for abrogating the contracts are pretextual. And so then if I'm Florida or DeSantis, the way I'm going to approach this is, number one, I'm going to say, hey, your contracts are bad to begin with. And then our reasons aren't just pretext. These are valid and legitimate reasons. And so when we switch over and look at the board's lawsuit against Disney, I want to look at what they say about the contracts and what they give as their reasons for taking the action against Disney that they're taking, to see if those are, seem to be legitimate, or as this would say, important government interests, and if the action they've had taken has been necessary. Basically, just to see how justified or how what kind of reasoning do they give that all of this action towards Disney was something that they needed to do. Anyway, so that's the first cause of action, and Disney is saying that the state has not identified any important government interest justifying its abrogation at all, much less an important interest that cannot be satisfied by modifying some provisions or some provision or provisions of the contracts. So give us a reason, and then show us a reason that you can't just fix by addressing some things within the contracts. It needs to be totally dismissed. But what Disney is going to say is that everything that the Florida has done underscores their motivation to punish Disney for its political speech, rather than to operate as a good faith counterparty in the continued development of the district. And that's really the gist of the entire complaint that Disney filed. But let's go on here. The second cause of action is the takings clause. This is most commonly like eminent domain. If the government takes your property, they have to fairly compensate you for taking it. The taking clause provides, nor shall private property be taken for public use without just compensation. Disney's argument is that contract rights are a form of property and as such may be taken for a public purpose, provided that just compensation is paid. And of course, they're saying that DeSantis is taking their contracts away without, and their board rights, contractual rights. Well, I guess it is just contractual rights here, without compensating Disney, and so they should not be allowed to do that. Third cause of action is due process clause violation. Due process is kind of has an ambiguous meaning. I've seen it just be called, it's the process that is due, a very circular explanation. But this is similar to what they were saying in the first cause of action, that there has to be a necessary kind of compelling interest, an important interest. But this one's a little bit of a lesser standard. There has to be a rational basis. And so what Disney is saying is that DeSantis' conduct towards it was without a rational basis and for only impermissible reasons. And of course, the Due Process Clause provides no person shall be deprived of life, liberty, or property without due process of law. And Disney says states must demonstrate that they are violating private interests only as necessary to promote state interests. The legislative declaration purporting to abrogate the contracts was not enacted for any legitimate state interest, nor was Senate Bill 1604. They were instead enacted to further an official state campaign of retaliation against Disney for expressing a viewpoint that Governor DeSantis and his legislative allies disagreed with. And that's all that one. Fourth, the cause of action is the actual First Amendment violation for violation of freedom of speech. Disney's public statements on House Bill 1557, the Parental Rights and Education Act / Don't Say Gay law, are fully protected by the First Amendment, which applies with particular force to political speech. The board's retaliatory interference with the contracts via the legislative declaration, which was to void the contracts, and its predicates, has chilled and continues to chill Disney's protected speech. In fact, interestingly, I did see an article where Governor DeSantis mentioned that Disney hasn't said a peep since all of this happened, and kind of proud of himself that, hey, we accomplished our objective here. Their woke agenda is they're not pushing it anymore here in Florida because we stood up to them. Well, that's kind of like Disney's probably saying, hey, don't say anything because that would undermine our position here that it's chilled our speech if we keep talking. Of course, I don't know if that's what they're saying, but it plays along with their argument. Anyway, this unconstitutional chilling effect is particularly offensive here due to the clear retaliatory and punitive intent that has motivated the board and the state legislature's actions at the governor's directive. And they quote here Governor DeSantis in a book he wrote where he says, leaders must stand up and fight back when big corporations make the mistake, as Disney did, of using their economic might to advance a political agenda. So the argument, of course, here is that this is what DeSantis is doing, is he's fighting back, not with speech, but with using the political powers to attack the contracts that Disney had. And then the fifth cause of action is also a First Amendment violation, but it's a little bit more broad than that one, because this one goes to it alleges the retaliatory reconstitution of Disney's governing body's structure through the through the enactments of Senate Bill 4C and House Bill 9B have chilled and continue to chill Disney's protected speech. So again, that goes not just to the decision to void the contracts, but basically all the way back to the beginning with the initial decision to schedule Reedy Creek for dissolution. Senate Bill 4C and House Bill 9B were motivated by retaliatory intent. And so what Disney's going to want to do is say, hey, all of this stuff is pretext. The real intent behind all of these bills was retaliation. And I'm going to just read this part of it because I think it's important here. Governor DeSantis called on the legislature to extend its special session for the express purpose of enacting Senate Bill 4C the very day after Disney made a statement about House Bill 1557. He repeatedly and publicly stated that he was fighting back for Disney's criticism of House Bill 1557, including at the bill signing ceremony. Key legislators publicly acknowledged that Senate Bill 4C targeted Disney, and I went over one of those in the last in the introduction of the case. And they called the law's passage as being highly irregular again, this is the point of all of this, is to show that they didn't go through a normal legislative process to actually consider the issues. It's more like the issues that they're raising were, in hindsight, or excuses just to be able to attack Disney by the bills that they did. So Disney says the circumstances surrounding the passage of House Bill 9B reveal the same retaliatory targeting. And finally, there are no rational bases for either Senate Bill 4C or House Bill 9B, and the purported justification for both are pretextual. And that's what it is. So the prayer for relief is that they want the legislative declaration voiding their contracts, and Senate Bill 1604, which says that they can't be enforced. They want the court to rule that those laws can't be enforced and to enforce the contracts. Same with all of them. And of course, the more broad one here, which I've highlighted, is that they want that Disney wants the court to declare that Senate Bill 4C and House Bill 9B are unlawful and enforceable because they were enacted in retaliation for Disney's political speech in violation of the First Amendment, and then issue an order enjoining defendants from enforcing those laws. So if Florida / DeSantis is successful in challenging the contracts and saying that the contracts are bad to begin with, they can't be enforced, then in my mind, all of the prayer for relief asking the court to enforce those contracts is, of course, pointless. And so the court would probably be inclined to say, well, let's figure out if the contracts are even valid and enforceable before we do all this everything else. But I think this other prayer for relief, which goes to House Bill 4C or Senate Bill 4C and House Bill 9B, would survive even if the contracts were bad. So I think that's going to be key in this case as we go forward, and I think that's going to give Disney. I'm sure there's going to be motions arguing like which case in the federal court or the state court should go forward and which should not. We'll probably see motions on those, and I think including this more broad scope of a prayer for relief that goes all the way back to the beginning is going to be helpful for Disney as they have those battles in the court. But that sums up. And then I should add too that Disney's asking for attorney's fees and costs. And then this is just a catch-all, grant such other relief as this court may deem just and improper. So that's Disney's lawsuit in a nutshell. It's that our contracts were valid. You're just retaliating against us, and all your reasons for passing all of these laws, the real reason is retaliation, and your reasons are bad. So with that, let's look at the board's response to all of this. Okay, now I have up here is Central Florida Tourism Oversight District's complaint against Walt Disney. This was filed in the 9th Judicial Circuit, so state court in Florida. And anytime someone files a complaint, of course, they're always presenting a one-sided story. So we saw Disney's side of the story. That's what we've gone over before. Now we're going to be reviewing the board's version of the story. So just like last time I've gone through and I've highlighted things that I think are key here, and I'm just going to cover some of these things. So this is a story we're familiar with, but they concede that there is no question that much good came from the special status that the Florida legislature granted Disney in 1967, which was the creation of the Reedy Creek District. But over time, Disney used its influence to obtain what must have seemed like permanent exemptions from the democratic checks and balances that apply to all other Florida businesses. For example, like other businesses in Florida, Disney is subject to building and fire codes. Again, this is getting into the reasons why Florida had to act against Disney. So one of the reasons they're giving is building and fire codes that are supposed to protect the lives and safety of its employees and guests. But unlike other businesses in Florida, Disney did not have to worry that these safety rules would be enforced against it. That is because the Disney-controlled district board never adopted any mechanism for the enforcement of those codes. So that's one reason is building codes, building and fire codes. Earlier this year, however, the Florida legislature took steps to restore the people's sovereignty and establish an independent board to govern the district. Now, I already think it's interesting. The only reason they're giving so far is building and fire codes. Like, that's what they're starting with. Like, okay. There's no. I don't know if there's been any problems with building and fires, building code problems and fires within Disney World. You know, that people are getting killed or something like that. I haven't looked, but anyway, they're concerned that Disney's deals violate basic principles of Florida constitutional, statutory, and common law. So that's what we're going to look for in their story here that they're telling. So the new board has already taken action to bring accountability, transparency, and normalized, even-handed administration to the government Disney used to run. It has adopted rules governing board conduct, so maybe that's another thing they were concerned about. Hired an outside financial advisor to ensure financial transparency, and retained new independent outside general counsel who are experienced in local government law and who, unlike the district's former general counsel, are not also Disney's lawyers. The new board has authorized the drafting of fire and building code enforcement provisions. So there's the fire and building code again. And the new board also has authorized the hiring of an urban planner to make recommendations to the Florida legislature about strategies to make the district more prosperous for those who live and work in and near it. So far, reasons for Florida needing to take action: concerns about building and fire codes, concerns, I guess, about board conduct, more financial transparency, and they wanted to hire a different outside general attorney. Urban planning, and again, fire code. Disney continues to insist that they are valid and enforceable. Oh, this is about the contracts. Basically, even though DeSantis people are coming in, doing great things, making sure there's building and fire codes, Disney continues to insist that their contracts are valid and enforceable against the district, and the district therefore seeks a judicial declaration regarding their invalidity. And that's why they filed their lawsuit in state court, to try and get a state decision ruling that the contracts are invalid, so then they can go to the federal court and say, hey, those first 4 causes of action are all bad. I thought this part was just kind of interesting. This court has jurisdiction over Disney because it is a Florida corporation with its principal place of business in Florida and is engaged in substantial and not isolated activity within the state of Florida. I just think that's good to point out, because all of the PR spin has so far been, this is a California company coming into Florida causing problems, but obviously this is actually a Florida corporation in their home state, that it's this infighting within Floridians. I mean, to a certain extent, I guess the Bob Chapek at the time obviously was in California. They're influenced by California, but they are a Florida business. So now we're talking about Disney's control over Reedy Creek, and this I think is also interesting historically, and just to hear some, again, the board side of the story here, DeSantis' side. So originally, Walt Disney Company had plans to develop the area of Central Florida. Those plans not only included a theme park along the lines of Disneyland in California, but also the construction of a planned community that Walt Disney called the Experimental Prototype Community of Tomorrow, or EPCOT, which is Epcot. The Magic Kingdom, typo here, theme park opened in 1971 and has been a financial success for Disney and the state of Florida. They've conceded that. Walt Disney's planned community within the Reedy Creek district, however, never materialized, although Disney later co-opted its name for its Epcot theme park within the district. I don't know why I can't read that. On its face, the Reedy Creek District appeared similar to other special districts periodically established by the Florida legislature. Like other special districts, the Reedy Creek District was authorized to exercise many of the traditional powers of local government, such as regulation of zoning, again, which is one of their concerns, and development matters, capital improvements, building code enforcement, and fire and safety matters. Okay, so far, those, again, we're still on those reasons. It's the fire safety, building code. The legislature also gave the Reedy Creek District the power to levy ad valorem taxes. Election to the Board of Supervisors required a majority vote of Reedy Creek electors who had to own at least 1 acre of land within Reedy Creek District and who cast 1 vote for every acre owned. We went over that before. But behind this democratic facade, Disney's rule was absolute. No individual owned 1 or more acres of property within the Reedy Creek District, which meant that no one could qualify to sit on the Reedy Creek Board of Supervisors. Indeed, Disney sought to limit residents in the district altogether, turning Epcot into a theme park instead of a residential community, and de-annexing the town of Celebration so the town's inhabitants could not dilute Disney's control. And what I actually think the board is doing here is that there is a 1968 Florida Supreme Court case that is about the Reedy Creek Improvement District, where the court concludes that, you know, it's all good. This is a good thing, and it's approved. And what I think they're setting up to do, and they've already talked about in the beginning, is that, yeah, at first it was all great. Everything was roses. But over time, things started going wrong. In fact, in 1968, when that Supreme Court case was passed, this was the plan, that Epcot was going to be an actual city where people lived, a city of the future. And all of that changed. Everything ended up being one-sided towards Disney. They took control that wasn't expected and changed the way that things were going to operate in ways that the legislature didn't anticipate when they created Reedy Creek. And so they're trying to set up distinctions so that when Disney tries to rely on that 1968 case, which they already referenced a bunch in their complaint, they can come back and say, well, it's factually different now. So I think that's what we'll see in the future. But anyway, let's see. So yes, there were these planned communities. Town of Celebration was annexed. In order to constitute the board, Disney would identify a suitable individual, deed him or her a parcel of land within the district on a temporary basis, and then nominate that individual for election to the board. Because Disney owned almost all the land within the district, Disney's chosen candidate won election to the board every time. Of course, Disney's gift to its hand-picked board members came with strings attached. On information and belief, this means that they're hoping this is something they're going to look at in the discovery process. Disney retained the ability to force a board member to return the deeded land and thus vacate their seat on the Board of Governors at any time. And when a board member left his or her seat voluntarily, they were similarly obligated to transfer the deeded land back to Disney. Under this governance system, Disney controlled who got elected to the board and could remove any member at any time for any reason. And then this is something that I think is kind of fascinating. Obviously, they're trying to present this in a way that's really shady, and maybe it is, but I'm very curious to see if there's someone they're talking to that's been aggrieved, has information that they want to share. And then, okay, this paragraph again goes back to the reasons why DeSantis needs to take over this board. Disney operated its own government within the district, establishing its own zoning and development laws and regulations, deciding how and when to enforce the building and fire safety codes. Again, that's really the thing that comes up the most. And even controlling law enforcement's access to his property. And I'd like to know more about that one because, you know, if you have private property, you can somewhat control law enforcement's access. It can't come in without a warrant. Anyway, Let's see. In short, it was both the governed and the government. No other private business in the state of Florida enjoyed the advantages Disney had through its control of the Reedy Creek district. And I am another thing I'm very curious about is to see how the Reedy Creek district compares to other special districts in the area, especially because DeSantis and their people say a lot, hey, we're leveling the playing field. We're going to make sure that Disney is given the same playing field that every other special district, or really say business in Florida, is given. But I wonder if there's any other special district where the governor is appointing his own people to oversee the district, whether they have dealings there or not, and then overseeing everything and kind of doing a hostile takeover like this. Because if that's not what's happening, then they're not actually leveling the playing field. They're doing something different. They're making it a unique situation, but on the other side of things. So, okay, now we're on this section here. The Florida legislature brings public accountability to the district. Over time, Disney exercises outsized political influence to extract additional exceptions and exemptions from the rules that apply to all other Florida businesses. I'd like to know which ones they're talking about specifically. It became a depressed example of crony capitalism. Disney used its special status to arrogate to itself an unprecedented authority to decide what the rules would be and whether they'd be enforced against Disney. And again, it seems like they're really just talking about the fire code and building safety, or what building code and fire safety. Florida's elected representatives decided that it was time to reform the Reedy Creek Improvement District and to put Disney on the same footing as every other Florida business. Again, but yeah, I already said that. I'm not going to say it again, but I do wonder how much other businesses have this type of political oversight. And if it matches, if it does, then no problem. But if it doesn't, then it seems odd. So the members of the Board of Supervisors are nominated by the governor and confirmed by the Florida Senate. So instead of Disney handpicking, now the governor is handpicking. So again, to me, it's kind of just like the pot calling the kettle black in some ways. Like, now we're going to have the same level of control that you once had. Anyway, signaling a further break from the past, House Bill 9B also changed the district's name from the Reedy Creek Improvement District to the Central Florida Tourism Oversight District. Next section here is Disney gets the Reedy Creek to rubber stamp illegal agreements. Using its control over Reedy Creek and the two municipalities that existed within the boundaries of the district, and this is going to be important, these two cities, the city of Lake Buena Vista and the city of Bay Lake. In the same way that the Reedy Creek Improvement District was a company district, Lake Buena Vista and Bay Lake are company towns. Disney selects who can live in the mobile home communities located on Disney's property in each municipality, and thereby controls who can stand for election to the respective city councils. Again, okay, so we have within the Reedy Creek Improvement District, there are these two cities, Lake Buena Vista, Bay Lake, and that's going to become really important to the district's arguments, because basically they're going to go on and say that the rights of these cities were kind of forgotten in all this process. So in their haste to seek to insulate Disney from meaningful government regulation, Disney and Reedy Creek, so the former board, failed to comply with basic statutory notice requirements, and the Reedy Creek district lacked authority to enter into any development agreement because it had not enacted an ordinance governing the process for doing so, as is required by Florida law. So that's their main argument as on the contracts, and now we're going to get into the actual causes of action here. So count one is failure to provide notice of public hearing. So we're getting into what are these shortcomings that they're claiming Disney had. So this statute here, which is Florida Statute 163.3225, if you're looking them up. But the main point there they have here is when you're doing a public hearing over a development agreement, it says notice of intent to consider a development agreement shall also be mailed to all affected property owners before the first public hearing. It requires publication in the newspaper as well, but I think they would concede that Disney published in the newspaper for Reedy Creek District. They're not going to concede that for Lake Buena Vista and Bay Lake. But they're highlighting this because they're going to claim here that Disney failed to do that mailing that was required. So Disney is not the sole property owner in the district. In addition to land owned by the district itself, other property owners within the district include private entities not affiliated with Disney and governmental entities. Now, I'd be very curious to know which entities those are and what their view is on this situation. But they don't name them. So the first hearing was January 25th on the new development agreement, January 25th, 2023. The second meeting was February 8th, 2023. And they concede here that the district published notice of intent to consider development agreement in the Orlando Sentinel. But the district did not mail notice of intent to consider a development agreement to all property owners affected by the development agreement. The failure to mail a notice of intent before the January 5th meeting, which was the first meeting, violated the mandatory notice requirements of 163.3225, and therefore, since the whole process was defective, the development agreement that was entered into as a result of those meetings is defective and cannot be enforced. I haven't done any research on case law and whether that's true. There is a legal principle called substantial compliance, which means that, if you substantially comply, maybe not totally, but everyone gets the gist of it, we'll let it pass. I doubt the Florida judge, if I'm thinking what's happening is happening, I doubt the Florida judge will be willing to grant a substantial compliance pass on this one. And maybe it's not allowed. Maybe it has to be followed by the letter of the law. A lot of the things are like that. But that's something that I'll probably have to look up. And that's not a bad argument for DeSantis. So count two is Ultra-Vires Act in violation of Florida statute. Ultra-Vires means beyond the scope of power, permissible power. So this act provides that any local government may, by ordinance, establish procedures and requirements to consider and enter into a development agreement. Absent the enactment of such an ordinance, a local government is not authorized to enter a development agreement. Now, my problem with this one is that there's a big difference in the law when you say may and when you say must. So in this situation, the statute says any local government may, by ordinance, establish procedures and requirements. It doesn't say must. There's no case law citation saying that has changed. And so I don't know how strong of an argument this is if Disney didn't establish, or if Reedy Creek didn't establish ordinances establishing procedures to consider development agreements, because it's just permissive and not mandatory under the language of the statute itself. The Reedy Creek District did not pass any law or adopt any regulations to establish procedures and requirements to consider and enter into a development agreement. So I don't know if that's totally fatal. If I'm just reading the statute, I'm thinking, well, that's not a very good argument because nothing says that they have to. We'll see where it goes. Count 3, district lacked authority and jurisdiction to enter into development agreement. And this is getting into the Bay Lake and Buena Vista argument, which I don't know how good of a job they do in presenting it because it's very convoluted to me. It doesn't make total sense, but the gist of it is that Bay Lake and Lake Buena Vista are their own municipalities, and so they have to follow the rules too. And Disney, I guess, forgot about that and passed the law without considering those municipalities. But let me just go through it here. Bay Lake and Lake Buena Vista had exclusive authority over comprehensive planning, land development regulations, development orders, and building permitting within their municipal boundaries, while Reedy Creek had exclusive authority over those matters for lands in the Reedy Creek district outside those city boundaries. Reedy Creek had no authority or jurisdiction to approve or regulate development-related activities on property located within the municipality's boundaries. The development agreement applies to property that is located inside the boundaries of Bay Lake and Lake Buena Vista, and to property that is located outside those municipalities' boundaries. So since the development agreement applies within these cities, and the cities didn't sign or participate in the development agreement, the development agreement is bad as to those areas. So the Reedy Creek District had no authority or jurisdiction on February 8th to approve or regulate this activity because Bay Lake and Lake Buena Vista did not conduct public hearings on, approve, or join as parties to the agreement. So the Reedy Creek lacked jurisdiction to enter into the agreement, basically acted beyond the scope of its powers. We'll see where that goes. Count 4 is violation of the Florida Constitution. Florida Constitution says that the district, a special district, I'm sure it doesn't say this particular district, but may issue bonds, certificates of indebtedness, or any form of tax anticipation certificates, blah, 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 to finance or refinance capital projects authorized by law, and this is the part they're keying in on, only when approved by vote of the electors who are owners of freeholds therein and not wholly exempt from taxation. Now, I don't know exactly what that means, but they're saying that in this case, the electors didn't vote on the development agreement. Count 5, failures to comply with certain statutes. Again, this one boils down to issues with Lake Buena Vista and Bay Lake, and basically it's saying that you didn't do stuff. So here it is. The Reedy Creek and the municipalities thus were required to hold at least one of the public hearings after 5 p.m. Didn't do that. It's just little technical things like that. Let's see, failed to set out full amendments to the land development regulations, failed to hold at least one public hearing after 5, failed to advertise these ordinances pursuant to statute. So they just go through all these technical failures and say because of these technical failures, the development agreement is unenforceable. Unlawful delegation of governmental authority is count 6. Development agreement contracts away the Disney's discretionary legislative power in multiple ways. And so when they start listing these multiple ways, again, it's just concerns about the here we have the maximum building heights is something we have a problem with. That the district should be deciding what the maximum building heights are, not Disney. And then they say that it doesn't allow for periodic reassessment of currently planned projects. That's supposed to happen every 7 years. And I guess the development agreement doesn't allow for that specifically. That's basically what I pulled out as being the main things that they were complaining about in this particular cause of action. They say multiple delegations of governmental power, but those are the ones that they mentioned. And then void is against public policy. Again, this is just saying we got it here again that they're failed to provide regulations related to safety, health, sanitation, or building safety. So it's really going down to building code and fire safety again is their main issue. Now, whether that merits a governmental takeover of the board, I guess that's what Disney's arguing about. Void is unconscionable because it's self-dealing and they lacked independent counsel for both parties, meaning that they have a problem with the fact that Disney and the prior board had an attorney that worked for both of them, guiding them through this process. And so that it's just a void and unconscionable agreement, both substantively and procedurally. And then lack of consideration, they're basically saying the district isn't getting anything out of this agreement. They just gave away all their power to Disney, not getting anything in return, so the contract fails for failing to have consideration. And that is what their prayer for relief is. And based on these things, they want the court to declare that the development agreement is void, unenforceable, and invalid. Same with the restricted covenants; those are just tied together. And they want that's basically it. There's no request for attorney's fees on their side, but maybe it'll come up later. So that's what the city's complaint is, and I mean, really, I just pulled out. When I first read that, my initial question is, well, what is the big problem here? You're saying that Disney needs to be on the same footing as every other business, but like, what was the problem that you're trying to solve by that? What abuse of power is there? And it seems like the main one they keep coming back to is the failure to enact enforcement mechanisms for the building code and fire safety. That's the one they come back to the most. They do make mention of zoning issues, but that one, I think they would concede that special districts, and they did. Special districts normally do oversee the development of their districts, and so again, that's an issue that I'm very curious to know. What is the difference between Disney and the other boards of other special districts, like say that might oversee Universal Studios, SeaWorld, or whatever other tourism districts there are in Florida? I'm sure there's a bunch of them. But it'd be very interesting to see how this compares. And my main question is, do any of these other special districts also have government appointed boards that are overseeing the issues that everything the board is doing? Are they financially transparent? Again, all these concerns that the board is raising about Disney, are these concerns also being addressed in other boards? Because if they're not, then it seems like this is governmental overreach in Disney's business affairs, and it doesn't necessarily level the playing field for Disney. It's just a special treatment of Disney, I guess is what I would say. So those are the claims and causes of action in both of them. And like I say, the next thing that will happen in these cases would be the filing of a response. And in filing a response, my guess is that there's going to be some motions, either motions to dismiss or motions to stay the case in both courts. Disney's going to ask the state court to hold on, don't make any decisions because we're in federal court first, and we don't want to waste judicial resources, time, litigating the same disputes in two different courts. The board's going to say the exact same thing to the federal court: hold off on your end of this, because in state court we need to first know if the contracts are good or bad. I think that's actually a pretty compelling argument, but we'll see what happens there. And I'm very interested to know what you guys think, so leave a comment. I also have a poll on my website, www.ficklefather.com. You can click on polls. I want you to take the poll on what you think about the situation, what you think should happen, what you would do if you're Disney. And until then, I'll be monitoring the docket and I'll let you know when I have an update. And subscribe if you want to stay up to date. And I've babbled now too long, so I will see you next time.